The broadcast is now starting. All attendees are in listen-only mode.
Thank you for joining us for the NAFTZ webinar on the new FTZ board regulations, next steps for operators and users. My name is Victoria Cartwright, Manager of Education and Meetings at NAFTZ. Please note after the speakers present, we will open up the discussion for questions. You are welcome to type in your questions at any time, but all questions will be held until the end. After the Zonecast, the PowerPoint will be sent to you again, and of course we welcome you to email us any additional questions you may have. I will now briefly introduce Phil Trickey, who will be moderating the event today. Phil Trickey is the Vice President of Finance and Administration for Yamaha. Yamaha operates a manufacturing zone in Newnan, Georgia, with over 1,000 employees. His responsibilities include finance, IT, logistics, and corporate governance, as well as overall customs compliance, including CT and PAT. With over 25 years experience in manufacturing accounting, it is my pleasure to pass it off to Phil Trickey, who will be introducing our speakers today.
Good afternoon, everyone. It's my pleasure to be participating with this important program on how the new regulations impact operators. That's going to be our primary focus today. And our speakers today are Brandy Hanback, who's the Managing Director of the Rockefeller Group. She has many years of experience in compliance, foreign trade zones, and has served as the past chair of the NAFTZ. I would list all of her degrees and accomplishments, but then we wouldn't have much time for the program. And Scott Winke, who is the Customs and Trade Compliance Manager for Abbott Global Pharmaceutical. Scott also has a tremendous background and experience, has been an active member of the NAFTZ for well over 10 years, serves on the board of directors. And I am extremely pleased to be working with these two talented folks to give you up-to-date information on the new regs, how they will impact your operations, and hopefully have enough time to answer many of your questions. As we move into our presentation, Victoria will slide into the first area, and I'll give a quick overview before turning it over to them. The new final rule was published February 22nd of 2012. Most of the provisions are already in effect from April. There were very significant changes made from the Notice of Proposed Rulemaking from 2010. Many of the NAFTZ's comments and your efforts at providing feedback to the board were listened to. Some of the key takeaways specifically for operators and users are improved access to the FTZ benefits, faster application processing and times, changes to the definitions which made things much more understandable and clear, and changes to the scope of authority that we think will streamline the process and make your scope and your applications understood and long-lasting. Some of the key definitions: production is the activity involving substantial transformation of a foreign article resulting in a new and different article having a different name, character, and use, or activity involving the change in the condition of the article which results in the change of a customs tariff classification of the article or on its eligibility for entry and consumption. This definition replaces definitions for both manufacturing and process and creates one single standard for both. And the speakers will go into how some of that translates. We have a definition for a subzone, which means a site or a group of sites that are established for a specific use. And we have usage-driven site, which is a site tied to a single operator or is used under the ASF. It clarifies that subzones can include a group of sites for a single user. So that was an important clarification.
Okay, this is Brandy Handback, and I'm going to pick up on the next slide. Some of the key application provisions for operators and users that are involved in distribution. So if you're a company that is in distribution and you're not in a zone, what the board has done through these new regulations is they've really separated the notion of getting land designated from getting permissions to do additional activities related to production. So because of that, if all you are really seeking to do is get a subzone, for example, that is for distribution only, your process and your application is going to be much faster, much more streamlined, because that whole additional piece relating to production authority has been separated out in a separate process. So if you are doing both, you'll have two applications that you're processing through the Foreign Trade Zones Board, where in the past you might have only had a single one for a subzone with production. But if you are in distribution, you'll have the benefit of a faster process that really just gets at designating the land so that you can then move forward with activation. As a subzone, there are two different timelines that could affect you. And again, we're talking about distribution only now, not getting into the separate process of production, which you may or may not need. If you're a subzone and your grantee has agreed to make your subzone acreage part of its overall activation limit under its grant, the Foreign Trade Zones Board will process that type of an application within 3 months, as compared to a subzone whose acres will not be part of the overall zone grant activation limit. That will take up to an additional 2 months for 5 months. So as an applicant company, you will have to coordinate with your grantee to know which of these timelines you're under, because if you want to get the subzone within 3 months, your grantee will have to agree that your activation acreage will be part of its overall grant limit. So the Foreign Trade Zones Board made this accommodation because they determined that if they could say that the subzone acres were part of the overall activation limit, it wasn't a significant enough change that they would need a full-blown process to review it, and that allowed them to shave an additional 2 months off of the process. So when you read those regs and you see references to 3 months and then separate references to 5 months, you'll now understand what the difference there is and be able to determine which process you fall under. In terms of the usage-driven site, if your grantee is under ASF, you will have the ability to do a minor boundary modification, which could be processed and approved in as little as 30 days. So this, again, requires you to coordinate with your prospective grantee and to know whether or not they're under ASF to see if you could get a usage-driven site instead of, for example, a subzone. However, if you have multiple locations, multiple buildings, multiple addresses that are part of your zone, you may choose to seek a subzone rather than a usage-driven site, just to make it clear for customs purposes and for operational flexibility that you want to operate that as a single zone. So there are some nuances there to be thought through when you're making a decision as to whether or not to pursue a usage-driven site or a subzone. But you at least have that option if you determine that your grantee is under ASF and that you are within the adjacency area of 60 miles or 90 minutes driving time from the outer limits of the customs port of entry. If you meet those two criteria, you may have the option of pursuing a usage-driven site and getting that approval within 30 days as opposed to having to do the subzone process. Okay. Let's see here. Okay. Now, if you are in the realm of needing production authority, and again, production refers to either manufacturing or processing under the old regs, you will not only have to get your land designated through one of the processes that we've already discussed, but you'll also have a separate, possibly concurrent process running in parallel to pursue your production activity. Note here that the board has made it very clear in the new regs that any type of production activity in the zone may not be conducted without prior authorization from the board. Under the old regs, there was some confusion about that and some, vagueness that allowed some companies to do certain types of activity as long as they weren't taking advantage of an inverted tariff benefit, for example. They were doing types of processing or manufacturing, but they weren't taking an inverted tariff. So they interpreted the regs as not requiring them to apply for production activity authority. Now, under the new regs, the board has made it very clear that if you are undertaking production activity, whether or not you are taking an inverted tariff benefit, you must apply for that authority with the board. So that's an important distinction, and for existing operations, something that, you know, people are going to want to think through, whether they're in a general purpose zone or a subzone, to make sure that they have the proper production authority for whatever activity they're doing if it involves a change in condition of the merchandise. Okay. In terms of the production authority, there are two paths that ultimately can be undertaken. One path is a notification, and it is sort of a fast-track review if the board determines that you fall under it. And the tough thing about this is you won't necessarily know for sure that you fall under it until you filed the application and the board reviews it and gives you an answer. So if you're trying to project timelines, the notification would be, you know, certainly an optimal way of getting a production authority fast-tracked and reviewed, but you might not want to make internal guarantees, for example, managing expectations until the board has initially reviewed that and confirmed to you that you will be processed under that procedure as opposed to the more full-blown procedure. So you'll see in the regs, based on these sections that we've noted here, two different paths. One for notification of production authority and one for a more full-blown production review. Okay. In terms of what must be contained in the notification, it's very minimal. So if you are an existing subzone, for example, that has had manufacturing authority for many years, if you remember what you had to put into your application, I mean, this is very different. It's very succinct. It's very minimal. But again, you won't necessarily know whether this is all you have to do until the board reviews this preliminary information and makes a determination as to whether or not more information is required and a lengthier review period will apply. So minimally, you will have to provide the identity of the user and its location, a description of the material components and finished products that are going to be associated with your proposed activity, including the harmonized tariff schedule at the 6-digit level and also the associated tariff rates. And if anything that you're doing involves products that are subject to trade-related measures, such as anti-dumping or countervailing duty proceedings, you have to explicitly notify the board of that so that they can use that information as part of their determination whether or not you need a fuller review. Scott?
Picking up from Brandy's comments on production authority, specifically noting that the preamble language in Federal Register Notice 12119 states that the adopted procedures create no new requirements for activity approved under the prior regulations. What's interesting is that there's the additional new requirement that Brandy has talked about relating to production activity process that's addressed in Section 414A, 22 and 37 that specifically speaks to the notification process, which is a more streamlined methodology to gain production authority. Under this process, many items previously required in an application will not be initially required, such as FTZ financial savings, FTZ production capacity, detailed company information, detailed employment information, and detailed market share and industry impact data. Slide 11 talks about the scope of authority. And specifically with this, the preamble language again in Federal Register Notice 12120 outlines that when determining scope of authority, the regulations first focus on written descriptions of the materials, components, and finished goods that are produced within the zone, and with the HTS number serving as a supplement to the written descriptions. Remember that while the proposed regulations did contain HTS requirements, in discussion with the FTZ board during the comment period, the HTS and the related descriptions were discussed as potentially having to be required at an 8 and a 10-digit level. The resulting regulatory language continues to be the board's existing practice and reflects the association's recognition of difficulties zone users would face in shifting to a sole HTS-driven approach. One additional thing to consider is if your strategic intent is to admit duty-free items to your zone, potentially as a logistical operation, it would be wise to also include these items in your scope of authority descriptions. The applicable provisions for operators and users for scope of authority for capacity. With this is actually a big win for the association, I believe. That the note, the preamble language under Federal Register Notice 12120 eliminated the provisions on notification of increases in production capacity, as well as a standard element of the scope of authority. Since 1991, the FTZ users have had to obtain the board's prior authorization to manufacture beyond the level of capacity already approved by the board for the operation. In the 20 years that the requirement has been in effect, increases in capacity have not proven to be controversial or to result in negative impacts. The elimination of this requirement allows for investment in the U.S. manufacturing where the application process is vetted through a single public comment period. That is critical for U.S. investment, I believe, at least in my corporation. The elimination also avoids the potential of restrictions to be placed on an entity that has invested in U.S. manufacturing. Keep in mind the original proposed regulations included the ability of the FTZ board to seek public comment again as a result of increased capacity notification to the board. Production notification processing. The procedure for notification of proposed production activity is addressed under Section 400.37 and states that within 120 days of receipt of the notification, the Executive Secretary will notify the applicant if further review is not needed for all or part of the activity that is subject of the notification, and that the activity in question may be conducted. Or further, review is needed for all or part of the activity that is the subject of the notification, with such activity precluded absent specific authorization. More detailed information will only be required if there is negative comments accepted by the board during the public comment period. Note that the new proposed safeguard in Section 428B speaks to the fact that where submitted comments must be probative and substantial and include evidence of projected impact. So comments that are proposed and vetted during the open public comment period have really got to hold weight and merit going forward. So there is a reduced risk of negative comments potentially impacting the applicant. If negative comments are accepted, an application similar to the current request for manufacturing authority would have to be filed. This is addressed in Section 423, 31, 32, 34, and 36, respectively. The board staff, however, can determine at any time that formal application would be required up until the approval of the notification for all or part of the imported components. Slide 14 speaks to production interim authorization. And further, under Section 437, subsection D, provides that the Executive Secretary may authorize the commencement of some or all of the activity on an interim basis. Interim authorization can be approved for applicants that demonstrate the activity is time-sensitive and obtain written concurrence from CBP regarding the projected time frame of the intended activity. Interim authorization is not available for materials or components subject to anti-dumping or countervailing duty order or proceeding or suspension of liquidation under AD/CVD procedures. Note that under 400.37 subsection C, a determination that further review is needed for all or some of the notified activity may also revoke that interim authorization until the board makes a determination after conduct that further review. Slide 15 talks about production and further review. If the board determines the notification for production authority requires further review, the application for production authority based on subsection 400.23 will need to be submitted. Under this section, the following information is going to be required, and here brings back in the micro-level detail that has been removed through the notification process previously discussed. The requirements that are required under the notification for production authority, I should say the application for production authority, is a summary as to the reasons for the application and an explanation of its anticipated economic effects, identity of the user and its corporate affiliation, the description of the proposed activity including finished products, imported materials and components, and for these items, they'll require the tariff schedule category at the 6-digit HTS level, which is current practice, the tariff rate, the confirmation whether the material or component is subject to a trade-related measure or proceeding, domestic inputs, foreign inputs, plant value add as percentages of the finished product value, and projected shipments to domestic market and export market in percentages. Continuing on with the requirements, estimated total or range of annual value of benefits to the proposed user. Again, this is broken down by category, including as a percent of finished product value. Annual production capacity for the proposed FTZ activities in units. Information to assist the board in making the determination under 427 subsection A3, which really speaks to impacts to quota and inverted tariff benefits, as well as 400.27 subsection B, which speaks to economic factors such as overall employment impacts, import and export levels, value-add activities, foreign competition, and domestic industry impacts. As well, information to whether the alternative procedures have been considered as a means of obtaining the benefits or sought are required, information on the industry involved and the extent of international competition, and economic impact of the operation of the area. And obviously, any other additional information that the Executive Secretary of the Foreign Trade Zone Board requests. Now keep in mind, the procedural safeguard under 400.28b speaks to where submitted comments received in production notification process must be probative, substantial, and include evidence of projected impact. This really goes a long way to help protect an applicant in the process and the ability potentially to avoid having to go to a full-blown authorization request for production. Slide 17 speaks to the applicant provisions for production for further review again, and comparing this information from the notification process to the application for production authority. The ordinary time frame for the action by the board is 12 months from the docketing when further review is involved, compared to 120 days for the notification approval. There's a standard 40-day public comment period for notifications when looking at the production notification process, compared to a 60-day public comment period when further review is involved. And the Executive Secretary may scope determinations as to whether the changes in the activity are within the scope of production activity already authorized. The benefits of the notification process, when you look at them at a macro level, it's a 4-month maximum approval time versus a 12-month approval time. You have shorter Federal Register public comment periods of 40 days versus 60 days, and the possibility for expedited interim production authority even faster than 120 days. But again, this requires a CBP letter indicating the activation can be achieved in expedited time frame. Potential issues in the activation for production authority include the Foreign Trade Zone Board can acquire or require formal application at any time, which creates a level of uncertainty for some companies. The list of company imported components and finished products by a 6-digit HTS level will be made available to the general public on the Foreign Trade Zones Board website. The utilization of the new application format is not going to be available until OMB approves the paperwork change, which is going to be about 4 to 6 months from the date of the regulations. And some of the older applications did not include duty-free inputs in the scope of authority. Next, we'll talk about fines and penalties. Section 462.62 addresses fines and penalties. The Foreign Trade Zone Act has a $1,000 violation per day provision. However, no penalties have been issued to date. The proposed regulations would have included a series of scenarios for penalty, including for activity outside the Foreign Trade Zones Board approved production scope of authority, where the $1,000 penalty would apply to grantees, operators, property owners, consultants, and administrators. The final rule significantly narrows the proposed penalty provisions for operators, users, to late filing of annual reports. Note that the preamble language supports the reduced penalty provisions to avoid the potential of duplicative penalty structures. The $1,000 per day fine or penalty does not apply to production scope of authority related violations because these violations are covered by the U.S. Customs and Border Protection under 19 CFR 146.81. Slide 19 talks about the miscellaneous provisions of interest to operators and users. Zone schedules are addressed in section 400.24 and directs every zone will be available to the FTZ board website after February 28, 2014. Section 440.47 indicates retail trade determinations will be made by the Executive Secretary as compared to the CBP in the previous regulations. Production equipment are addressed under section 400.15, outlining the benefits that are explicitly limited to equipment and parts of equipment destined for use in production activity. And the burden of proof factor is spoken to in sections 428, 449, monitoring reviews of zone activity, and section 400.52 that speaks to notice of hearings. These sections support applicants by regulating objectors to FTZ benefits should provide information that is probative, substantial, in addressing the matter of issue relative to the nature of the proceeding, including adding evidence that projected direct impact of the proposed authority. With that, I think we can transition to some open questions.
Victoria, before you do the questions, I just wanted to add a comment on the application process. Even though Scott is correct that the new formats will not be available for some time because of the requirement that the Office of Management and Budget has to review and approve them, the board has compensated for that by making it available to applicants to use existing formats but only fill out abbreviated information. So if you go on the Foreign Trade Zone Board website and you look at the information they have there related to the new regulations, they actually have said for certain types of applications you can use one of the existing formats, but you only need to fill out, questions, whatever it is, 1, 3, 5, and 10, or something. That's just a hypothetical. But you only have to fill out a limited amount of information. So if you are looking to do something sooner than later, you can use the existing formats in an abbreviated way to file a notification, for example, for production. And you can find information about that on the Foreign Trade Zones Board website.
Great. So for our first question, as an operator of a distribution FTZ, what are the specific items you should be keeping in mind and focusing on when updating procedures in Customs Manual?
Okay, so in the context of the Foreign Trade Zones Board regulations, I wouldn't say there are a lot of changes that would impact your CBP procedures manual, but for example, one of the things that was part of this regs update was the change in the annual reporting period. So your manual may have said, made reference to your Foreign Trade Zones Board annual report and the timing of when that would be filed based on the old reporting period of October 1 through September 30th. Starting this last reporting year, the board implemented a calendar year reporting in anticipation of the new regs, which is January 1 through December 31st. And your due date to then submit that information to your grantee may also have changed as a result of that. So that might be something that you would want to look for in the context of your procedures manual. But there shouldn't be a huge amount of references in your procedures manual for customs that would be impacted by the Foreign Trade Zones Board regs, especially if you're not involved in any type of production activity.
Great. And if everyone could keep in mind, if you could just type in your questions at the bottom of your screen, it should drop down and we'll receive those and ask them for you. What would you say is the one thing that you hope attendees will take away from this presentation, since there's so much information?
This is Scott. I would say that from an operator user perspective, I am really excited about the ability to gain production authorization through the notification process, providing there's no negative comments in the open public comment period. I think that that is really going to expedite and provide some zone users the ability to quickly gain access to zone benefits. And I would say that the executive committee met with the FDA 2 weeks ago, and one of the comments that was striking was that the FDA actually asked us how they could inform an importer how to use a foreign trade zone to actually benefit the operations and improve the regulatory guidance under the FDA's jurisdiction. And they were strikingly surprised that they could gain access to FTZ procedures through this notification process within 120 days.
Another thing I think that's important, and it kind of comes out when you look at the regulations in their totality, is for existing operators, and I'm guessing a lot of our attendees on the call are existing operators, many of whom have a scope of authority and are trying to figure out how to reconcile some of that information in the preamble, which says that the board doesn't intend that existing operations will have to make any changes, with the requirements that come up later in the regs that say that your scope of authority has to cover all of your production activity, including all of your inputs and finished goods, and that the new standard is really a 6-digit HTS, even though they recognize that written descriptions, could cover a broader range of products. That kind of leaves a lot of companies grappling to figure out, are they covered or are they not? And Scott gave a good example about, for example, duty-free products, that come into the zone that are subject to production activity, but that an operator may not have interpreted needed to be part explicitly of their scope of authority. So I think what's important for existing operators is to go back and actually read the applications that you filed. If there may have been one, there may have been multiple, updating your scope of authority over the years, and get comfortable that your written descriptions really do cover you in terms of what you're doing, both in terms of raw materials and in terms of finished products. If you're not comfortable, one of the things that the new regs provide is the ability to do a scope determination, so to write a letter to the board to represent what your scope of authority is as you understand it, and what you're doing now to confirm that what you're doing is within your approved scope, or whether or not there is some sort of notification that you need to do to bring your scope up to date. And that will be important. And there's some old applications that had no HTS references. There are some applications that had some HTS references but had, things, buffers, qualifiers in it that said, this represents approximately 80% of what we do or 90% of what we do, but we reserve the right to do other things too, as long as it's related to the production of widgets or whatever it is that they make. And so that they had some buffer. And over time, the board has had different tolerance levels for those kinds of general descriptions and have approved grants containing some fairly general language. So that's an opportunity, but it also puts the onus, on the applicant at the end of the day to make sure that you are covered for what you're doing, and to definitely understand that anything that you might be doing that involves, parts or products subject to anti-dumping or other kinds of trade restrictions, that really now is explicitly called for in the regs to be part of your approval. So those are things to be thinking about as an existing operator.
And one of the guests asked if they could get the references to the various regulation sections each of the speakers had made. I know the session will actually be recorded as well as the Q&A portion, and it will be emailed out to everyone if there was a specific slide they were referencing.
Yeah, a lot of them were included in the actual slides. I heard Scott make some additional references, but those FRN numbers that you saw in several of the slides out to the right actually refer to the page number within the Federal Register dated February 28th, 2012. So you can go on the board's website and pull down the Federal Register notice, or you can go to the Government Printing Office website and pull down the actual Federal Register notices, and those page number references will take you to the page in the final rule that refers to the points that we discussed, in addition to several of the sections that we cited in the presentation.
What is the expected time from start to finish for a production subzone to take?
That's the key question. Well, the subzone, remember now, is the land designation. So that's a 3 to 5 month process, depending on, in terms of the review. That's after you've prepared it, after you've gotten your local grantees support and they've gone through their resolution or whatever they need to do locally to support it, which in some places can take longer than others. Then once the board dockets it and accepts it for final review, you're looking at a 3 to 5 month period. That is separate from the production authority process, which could take you anywhere from 4 months up to a year, depending on which process you end up falling under, and you may not know ahead of time which process you're going to fall under until you file the notification and the board has an opportunity to review it, or even publishes that first 40-day comment period and looks at what they get, if anything, in terms of opposition. So One of the things you can do, though, if you really are not sure whether or not you're in a new industry, for example, to the Foreign Trade Zones program, and there's really no precedence for the type of product that you want to produce, you can certainly contact the Foreign Trade Zones Board and speak to them about what you're proposing to do to try to get a feel from them as to whether or not there's been a history of opposition or concern regarding the products that you intend to make under zone procedures. You can also look at the prior decisions of the board and get a pretty good idea as to whether or not you're likely to fall under an industry that would require fuller review.
Do any of the changes directly affect export compliance regarding FTZs?
I can't think of an example where there's something in the new Foreign Trade Zones Board regulations that would change your export compliance program or approach. But one thing that maybe impacts exports, again, is this notion that in previous years, under the previous regulations, there was an interpretation of the regulations which suggested that if you were bringing something into the zone and you were producing it just for export, that you would not have to have an approval by the Foreign Trade Zones Board. Now they've made it very clear that any production activity in the zone that changes the condition of the merchandise, whether or not it's for export only, has to be reviewed by the Foreign Trade Zones Board. So, I think that's probably the closest thing that would impact exporters.
This is a question for both speakers. Was there anything in reviewing the new FTZ board regulations that surprised you?
That's interesting. That's an interesting question. Scott?
I would start out and say that I was somewhat concerned with the capacity notification, the shift of tariff within the zone notification that was in the original board proposed board regulations. I think that the association, through its comments and collectively through all the comments that were submitted through the open public comment period, really laid some groundwork for the FTZ board to consider the fact of how the negative impacts could be construed by a zone user, i.e., if I'm running a zone and I'm making a financial decision today to expand or bring U.S. manufacturing into my local plant here that happens to be in my foreign trade zone, I'm expecting that through my zone opportunities, I'm going to have a return on my investment. And under the proposed regulations, there was the potential that I could have restrictions later on if through nothing else but efficiency, I gained capacity increase. And not knowing that manufacturing authorization was going to have longevity behind it after it was approved on the original board application was of great concern to U.S. manufacturers. I think the board listening to the comments that were submitted and their openness to change some of the language to make it more simplified, make it more certain, I think that the overall response of the comments that were submitted by the association and collectively the entire group that submitted comments was fantastic. And that surprising that the board listened to the comments and took such a proactive approach to assist zone users.
One of the big challenges I had with the original notice of proposed rulemaking was in the fines and penalties area, where that you could be facing a $1,000 a day fine if you exceeded your scope, and your scope was tied to capacity, which was somewhat vaguely defined. So if you had an approval for capacity and your business grew, and we want businesses to grow and we want to add employment, but if you grew by 7% a year and the board determined that normal growth should have been 4% a year and you were outside your capacity, in theory you could have been looking at a $1,000 a day penalty for having grown beyond what was expected. Getting that language out of the final rulemaking, I think, takes a lot of uncertainty out of businesses making decisions and does open up the program while the revenue is still protected with customs regs. If you have improper tariff classification or if you're taking an improper duty inversion that hasn't been imposed, customs has always had a hammer to go after those and still does. So I was very shocked to see the wording in the first place, and pleasantly shocked to see that wording finally removed after all of the comments.
So I hear a theme that we're pleasantly surprised with the FTZ board. Brandy, do you want to add to that?
I agree.
And is it a correct assumption that the new regulations apply primarily to production activities and not for pure distribution?
I think it's interesting when you look at the history of the program to see how we've come kind of full circle. You know, there was a period of time, believe it or not, when distribution subzones were considered controversial because it was sort of a question as to whether or not if you weren't involved in manufacturing or value add, could you really demonstrate a significant enough, sufficient enough public interest standard to get a subzone approved that didn't involve manufacturing. And now it's almost de minimis. If you're doing a subzone, you can get it applied for and processed and approved very quickly. Distribution is a no-brainer. You don't even have to, you know, go into any specifics about that in your subzone application. It's very land-oriented, the application requirements that don't involve production. And really the most controversy and the most in-depth review comes up when manufacturing is involved. So I think that is somewhat reflective of trade policy and hopefully something that will continue to evolve over time because, you know, at the end of the day, I think we should be encouraging both. And I think, you know, where manufacturing and particularly exports are involved, it should be sort of a similar approach that is inherently good and is something we should be encouraging. And I still sense, you know, some restrictions and some challenges with certain types of applications that are clearly manufacturing and export oriented, and I hope over time we'll be able to address those concerns and make that just as streamlined.
What would you recommend as the best strategies to use in going through the regulations for those of them who are overwhelmed?
Yeah, you know, the new regulations are actually quite, the way the final rule came out, are pretty short. And almost the first half of the Federal Register notice is all preamble. So if I was starting from scratch and really just wanted to get a good handle on the regs, I would jump all the way to page 12-140, 12140, and you've actually got, I mean, it's less than 20 pages that is actually the regs themselves. And a lot of the beginning of that is definitions. So even though, you know, when you're comparing the old to the new and the interim, the discussion of all this gets fairly complex, and the preamble is certainly the biggest part of the regs where they go through and explain all the comments they got and why they did what they did. That's a useful reference when you want to go back and understand something better. But to really just kind of get a handle on what the new regs require, I would jump to the back and start with 400.1 and, you know, just read them once through and highlight areas that you want to understand better, and then maybe go back and look at the preamble, then maybe go back and compare to the 91 or the interim proposed. But really, if you just tackle the true final rule portion of these new regs, it's pretty concise. And what the board has done to a great extent has streamlined the way the regs are even laid out and tried to put similar issues together. One of the problems with the 91 regs is that you would have to search different sections to find information that all related to the same thing. The new regs have attempted, and I think with a great degree of success, to put things logically where you would look for them in trying to understand what's required for a production authority, for example, or what are my responsibilities as a grantee, to try to kind of put those all together in logical order. So that's how I would tackle it.
Can I interject a quick summary and let Scott and Brandy correct me where I'm wrong? But for an existing operator that had manufacturing, which is now processing production authority, I think the two key takeaways from the new regulations is to make sure you've got a scope determination and that what's in your scope reflects what you're doing. And if you think there's any question about it, file the new updated scope determination to make sure that your outputs and inputs are understood by the board, with the product descriptions being the key, but with the 6-digit HTS codes as backup. And the second big one is make sure your annual reports are on time.
Yeah, I would agree. I mean, when I looked at the new regs that came out, I isolated myself in a room and I dissected it from the perspective of I'm an existing operator. I looked and highlighted the sections that really dealt with ongoing operations first, and then I reviewed those in comparison to what my ops manual states, how I was going to run my zone, to make sure that my operations manual is in alignment with what the regulations are saying I should be doing, and then compared how my day-to-day business practice also overlaid in parallel with the new proposed, the new regulations. And I looked at it purely from a day-to-day operational perspective because I didn't have an immediate need to look at proposed new activation or proposed new authority for production.
It's 16 pages. I just counted it. So if you really just want to tackle the regs and an overview approach and read it once through, you know, start back there on page 12140 of the FR notice, and you'll have 16 pages just to review.
And do it on a night that you're having trouble getting to sleep.
And given that we have a few extra minutes, is there any one topic that you wanted to go a little bit more in detail on?
I think for operators and users, you know, this was really specifically designed to address their issues. One thing I'll mention that I think is a real plus, we skimmed over it, but I mean, to understand the background of it, it seems more like a grantee issue. But that bullet point we had that said that zone schedules will all be published on the Foreign Trade Zones Board website, that was really done at the request of the NAFTZ and specifically the Operator User Committee, because companies, especially companies that have zones in multiple parts of the country or have operations that they want to look at creating zones, wanted to be able to very quickly look up a grantee zone schedule, know what their fees would be under that zone, be able to quickly tell, you know, what they would need to do to apply to have that grantee sponsor them, and not necessarily have to call the grantee and divulge their company's name or a lot of details at the feasibility phase of just trying to figure out cost benefit. You know, okay, if we set up our plant in California as a zone, I'm trying to figure out all my costs and all my benefits. What are the grantee fees going to be? You know, to have a place they could just go and kind of look that up. So that's actually a big win, because it's never been something before that you could rely on being available even on the grantee's website. So the board is now going to have all of that. It's going to take them a couple years, but they're going to commit to having all of that available on their website, where you can, you know, look up and determine, you know, and if you just want to also benchmark a little bit and go, wow, you know, we're paying $15,000 a year on a grantee fee in one part of the country, but only $5,000 in another. You know, why is that, and what are the different things that are being used to justify my fee in one location versus another? So I think that's going to actually be very helpful to operators and users over time, and it has not been something that ever existed before that way.
How does the ADD affect the notification process?
Well, it pretty much knocks you out of it. If you report to the board that you have products subject to an anti-dumping or countervailing order, it basically suggests that you will be in a full review as part of the board's you know, review of the public interest basis for your application. So, I mean, it explicitly, I mean, one of the changes from the new regs to the old regs, if you look at it, is the number of references to anti-dumping and kind of the more careful review and emphasis of the Foreign Trade Zones Board on products subject to anti-dumping. So, you know, you have to know going in if that affects you, and I think you have to be prepared if you're in that realm that it may not be just as simple as PF status on anything that comes in subject to AD/CVD, which was the baseline rule before, and happily the board kept that standard in the new regs, but they also implemented explicit reporting requirements and the possibility of fuller reviews on those types of applications.
Would it be safe to say that while trying to significantly encourage production, the board is still shying away from controversial things and wants to make sure they can study those deeply so that they can speed up non-controversial but not get bogged down in controversial things without due process?
Absolutely. I mean, and it's a public interest-based program, and by definition, if you have opposition, then there's a question as to whether or not it's in the public interest and whose private interests, are creating a net positive interest for the country. So you may feel strongly that, you're bringing manufacturing and hopefully export activity to the United States, but somebody who opposes your application may have a different view. And the board then has to sort through all that and come up with a net economic assessment for the public interest summation. And so, yeah, absolutely, I think that's exactly what's happening.
Great. And Scott, did you want to highlight any other topics in our last few minutes?
I think I'm good.
Great.
I've got one that really doesn't affect operators so much, but it may reflect some unusual things that you may start seeing, and it relates to grantee liability, which isn't the subject of this, but it has changed a bit in terms of what will make them potentially responsible. So if you send a copy of your customs manual to your grantee and it comes back unopened, postage paid, understand that that may be part of their new self-defense mechanisms, that they may not want to get as involved in your business as they might have in the past. So that is still being fleshed out and understood as to what's intended versus what's written, but that was the subject of some very heated debate at the spring seminar, and will be part of our Zonecast in July. But there are some significant changes related to grantees and what makes them responsible that may seem counterintuitive to some of us operators and users.
It's a great point, and as a result of that, you might end up seeing grantees coming back with updated agreements that they want you to sign, certainly updated zone schedules, and just kind of updated policies with respect to how they administer their zones, not only because of liability issues, but also under the uniformity sections, which, and the public utility sections, which have been greatly fleshed out and, are something that are being studied carefully by the grantees.
So this is Scott. I just want to confirm there's an upcoming grantee webinar also?
Yes.
Yes, there's going to be a...
I would recommend that the attendees to this session also join that if they're capable of that, because I think, to Phil's point, you're going to see a lot of the general concerns and how it applies, how the regulations apply to the grantees, and that may help understand nuances or changes in your relationship with your existing grantees, and you'll gain a little bit more information from that webinar as well.
It's a great point.
And we have one last question. We are getting ready to provide notice to the FTZ board. We had one item that is subject to ADD. So basically, what you just stated, we will be required for further review, or only if the board requires it.
Only if the board requires it, but it is definitely one of the triggers that they're looking for in determining whether or not a fuller review is required. So it's not mandated that you have to be in a fuller review, but it's certainly possible.
Great. With that last question, I'll just close us. Thank you. Special thanks to Brandy Handback, Scott Winke, and Phil Trickey for making this webinar possible, as well as everyone on this call for attending. So you'll be receiving an email from me shortly.
Thank you very much.
Thank you.